A silent 6-3 decision that transforms power across America. Most citizens remain unaware it even occurred. There were no breaking news alerts, no political rallies, and no evening news specials. Yet early yesterday morning, the Supreme Court delivered a 6-3 emergency opinion that just reshaped the equilibrium between the people and their government. And more than 600,000 individuals will experience the consequences immediately. What follows next could touch every American who deposits funds, sends messages, journeys abroad, or engages with national agencies. This isn't merely another border case. This isn't simply another data protection case. This is the Supreme Court intervening to declare that provisional truly means provisional, that constitutional safeguards remain intact, and that regulatory bodies and local magistrates cannot silently govern the nation from behind closed doors. For upwards of 10 years, the machinery functioned in reverse. Regional magistrates halted border enforcement nationwide. National agencies initiated monitoring schemes without judicial authorization, and administrators prolonged provisional initiatives endlessly, all without legislative approval on any of it. That period has concluded. If you value constitutional boundaries, personal privacy, presidential authority, border enforcement, or electronic monitoring, you must take notice. Because what the justices accomplished connects all of these elements together. Before we examine the specifics and the repercussions, ensure you are following so you don't miss the upcoming significant ruling. These decisions are arriving rapidly now. Disclaimer: I'm not an attorney, and this isn't legal counsel. Firearm statutes shift quickly and vary by zip code. Always consult a licensed lawyer and your local ordinances before acting. Section 1. What the Supreme Court just accomplished. The justices released a 6-3 judgment, stating that the national administration may terminate provisional protected initiatives without demonstrating compassionate reasoning to a federal magistrate. The justices also stated that national agencies cannot exploit crisis designation as a gap to operate monitoring activities endlessly without judicial authorization. This carries weight because for the previous dozen to 15 years, provisional initiatives stretched across decades. Monitoring initiatives extended across years. Regional magistrates overruled national strategy. This opinion starts to dismantle all three simultaneously. This represents an architectural judgment. It eliminates appointed officials from decision-making circles and restores constitutional authority to its proper place. The legislature drafts the statutes, the administration implements them, and the judiciary interprets, not commands, national strategy. Section 2. Why 600,000 individuals sit at the heart of this provisional protected status. TPS was established in 1990 to provide brief assistance to migrants escaping conflict or environmental catastrophe. The initiative was crafted to endure 6 to 18 months, yet administrative renewals transformed 18 months into 12+ years for over 600,000 persons, predominantly from Venezuela and Haiti. When the previous administration sought to terminate TPS, advocacy organizations filed suit in federal court, and magistrates blocked the strategy coast to coast for years. What TPS demonstrates is the template. Provisional becomes lasting. Administration becomes governance. Courts supersede the legislature. TPS was never solely about migration. It evolved into a test scenario for whether federal magistrates or national agencies could silently manage migration policy without elections or statutes. Section 3. Magistrates seized command. To grasp why this opinion carries significance, you must comprehend how border enforcement genuinely functioned for the previous decade. In principle, the administrative branch governs migration. In reality, a select group of federal magistrates ended up governing it instead. Here's the mechanism. Whenever DHS or the executive mansion attempted to modify enforcement, advocacy organizations would promptly file suit in the Northern District of California. They weren't selecting that jurisdiction accidentally. They were selecting it because of its history, and it succeeded. Two outcomes followed every instance: a coast-to-coast injunction, halting enforcement everywhere. Years of appeals that maintained the injunction active for millions of Americans. It appeared as though migration statutes existed merely on parchment. Meanwhile, the individuals establishing the regulations weren't elected representatives. They were regional magistrates and appellate boards who never had to justify those decisions at the voting booth. The Supreme Court reversed that entire approach in a solitary opinion. They didn't merely terminate one injunction. information. They terminated the concept that one magistrate can nullify national strategy for the entire nation. That's a substantial transformation few commentators are recognizing yet. Section for the monitoring connection. While reporters were occupied discussing TPS, the Supreme Court was addressing something far more substantial: how the national administration has been exploiting provisional crises to rationalize extended monitoring initiatives. That's where FinCEN enters, a modest bureau within the Treasury that most Americans have never encountered. Following a financial crime surge in 2018, FinCEN initiated what was intended to be a 90-day crisis initiative. Instead, it silently persisted 6 years. Throughout those 6 years, the Bureau tracked 30 million banking transfers monthly. No judicial authorization was necessary. No reasonable suspicion was required. And here's the element individuals overlook. The overwhelming majority of those transactions belonged to entirely typical citizens. The algorithm didn't distinguish whether you were operating a company, assisting relatives, covering rent, or transferring funds between accounts. The justices examined that system and stated, essentially, negative. The Fourth Amendment didn't disappear simply because the administration discovered a quicker method to gather information. That judgment extends well beyond migration. It compels the national administration to reacquaint itself with judicial authorization requirements for the digital era. Section 5. Privacy Restoration. For generations, the administration employed a straightforward argument to rationalize mass monitoring. If you disclose information to a financial institution or technology firm, you've willingly surrendered it, and therefore you no longer possess privacy entitlements in it. That legal framework is termed the third-party doctrine, and it traces all the way back to the 1970s, long before digital banking, mobile devices, cloud repositories, encrypted communications, or financial algorithms emerged. The Supreme Court has been gradually resisting that reasoning in contemporary cases. In Carpenter, they stated, mobile location information still demands judicial authorization. In Riley, they stated authorities cannot inspect your mobile device without judicial authorization. In Jones, they stated GPS monitoring activates the Fourth Amendment. This fresh 6-3 judgment advances even further. It treats financial metadata, not merely substance, as something that still belongs to the individual, not merely the corporation that holds it. That carries weight because metadata exposes patterns: where you reside, whom you compensate, how frequently you earn, and how you transfer funds. In plain terminology, the justices just transported the Fourth Amendment into the contemporary financial structure. That means agencies don't get to gather first and rationalize afterward. They require reasonable suspicion beforehand, the identical manner the Constitution always intended. Section 6. The Authority Transformation. Nobody anticipated. For generations, two branches of administration have been competing for command over how provisional initiatives conclude. The legislature composes the statutes, the administration implements them. Yet, federal courts, particularly within the Ninth Circuit, began inserting themselves as guardians who could prolong initiatives endlessly through injunctions and procedural postponements. The Supreme Court's 6-3 judgment rejected that third participant model and reinstated the original constitutional sequence of authority. Essential elements. Provisional status concludes when the statute or administration declares it concludes, not when a regional magistrate disagrees. Courts cannot compel extensions based on compassionate policy arguments. Administrative enforcement cannot be obstructed endlessly without statutory foundation. To comprehend how significant this is, compare it to DACA, created by executive memorandum, extended for years through injunctions and then trapped in legal uncertainty because no branch possessed final authority. TPS followed the identical strategy, except this occasion the Supreme Court declined to permit it to become lasting through inertia. The judgment didn't merely liberate 600,000 TPS recipients from uncertainty. It reaffirmed who genuinely governs the nation and under what constitutional authority. That's a far more substantial narrative than migration alone. Section 7. Monitoring confronts the Fourth Amendment. Most individuals didn't anticipate the privacy angle emerging, yet legal academics did. The identical judgment that struck down judicial extensions also targeted bulk monitoring initiatives operated through financial institutions, telecommunications firms, and border agencies. The Supreme Court indicated that sharing information with a financial institution or provider does not eliminate Fourth Amendment safeguards. significant departure from how agencies have functioned for 20-plus years. Supporting precedents. Carpenter versus United States. 2018 Mobile Location Information demands judicial authorization. United States versus Jones. 2012. GPS monitoring constitutes a search. Riley versus California. 2014. Mobile devices are digital containers shielded from unauthorized inspection. Combined, those precedents narrowed the antiquated third-party doctrine, and this fresh judgment continues that pattern by closing the entrance on bulk financial monitoring through administrative summonses. Millions of Americans who have never violated the law were being tracked because algorithms identified unusual patterns. That channel now must satisfy constitutional standards again, something privacy attorneys have pleaded for since the Snowden period. Section 8. The genuine victors and defeated. It's straightforward to claim 600,000 individuals gained, yet that understates the victors by an order of magnitude. The more immediate beneficiaries were victors' TPS recipients obtaining clarity after years of uncertainty. Modest company proprietors targeted by FinCEN. Financial examinations. Typical Americans shielded from unauthorized information collection. Yet, there are defeated agencies that depended on crisis authority to circumvent the legislature regional magistrates who employed injunctions as policy instruments. Advocacy organizations whose jurisdiction shopped for favorable courts. Migration advocates dread households will be divided. Privacy advocates dread agencies will discover new gaps. Legal academics worry about disorder throughout the transition. The Supreme Court majority dismissed those concerns and contended the genuine disorder was caused by permitting provisional initiatives to become lasting without accountability. Section 9. The electoral implication. This judgment quietly reconfigures American politics advancing into 2026. For the initial occasion in years, voters recognize the administrative branch genuinely governs border enforcement again, not regional magistrates, not advocacy organizations, not administrators. It also positions monitoring authority back where the Constitution intended. The legislature must approve, and courts must oversee through judicial authorization. Political ramifications. Elections now determine border enforcement policy. The legislature can no longer delegate difficult decisions to agencies. Privacy regulations must be contested publicly, instead of concealed in memoranda. Both political parties lose a shield for years. They could fault activist magistrates or appointed agencies for consequences. Now, they own those consequences directly. In a nation where migration, privacy, and monitoring are priority concerns for independence, this judgment ensures those debates occur where they belong in elections, not concealed chambers. Section 10. The legal chain reactions ahead. The immediate TPS and FinCEN transformations are merely the commencement. The constitutional reasoning of this judgment creates fresh opportunities for challenges to DACA extensions. Identical provisional to lasting problem border equipment inspections. Carpenter reasoning applies bulk telecommunications metadata initiatives post-Snowden framework. Administrative summonses. No judicial authorization equals fragile foundation. Chevron deference cases. Agencies exceeding statutory boundaries. Migration attorneys already anticipate petitions challenging provisional protected status renewals for additional nations. Privacy advocates expect fresh litigation against FinCEN, DEA, CBP, and DHS monitoring instruments. Constitutional academics believe this judgment accelerates the Supreme Court's multi-year effort to recenter administrative and legislative authority. The fundamental message is straightforward: no more constitutional gaps disguised as crisis initiatives. A restoration toward constitutional administration. For years, Americans resided in a nation governed by injunctions, agency memoranda, and monitoring architecture that nobody selected. This judgment finally compelled a reset. Provisional means provisional again. Judicial authorizations mean judicial authorizations again. Elections matter again. The broader lesson from the court: if administration authority expands without accountability, constitutional boundaries become recommendations. This judgment thrusts those boundaries back into effect. If you desire grounded explanations of these significant legal transformations, not sensationalism, not alarm, not bias, ensure you are following. Major Supreme Court decisions are arriving rapidly, and the upcoming one could reshape how your entitlements genuinely function in practice. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.